Thank you. Just hours ago, the Indiana Supreme Court adjourned after hearing the first arguments on abortion access. The lawsuit is one of two challenging Indiana's abortion ban, which initially passed after Roe v. Wade was struck down last summer. Today's case questioned the constitutionality of the ban. Planned Parenthood and other organizations say the state's constitution protects privacy in these cases. It's been just about 6 months since lawmakers passed the near total abortion ban in Indiana. The only exceptions would be cases of rape, incest, or to save the mother's life. The state argues ethics tell us not to end an unborn human life.
Science tells us that abortion terminates the existence of a distinct living human being with unique DNA and the capacity to direct its own development. Ethics tells us not to end innocent human life.
Chief Justice Loretta Rush asked a lot of questions today, focusing in on the right to a mother to make a decision she believes is saving her life. On the other side of the issue, Ken Falk with the ACLU of Indiana says the Constitution is not frozen in time and should not be interpreted only in the lens of the 1850s.
Of course, the founders in 1851 were not attempting to advance women's rights and were not thinking about reproductive issues. Although it's worth noting that at the time of our first Constitution, in a common law, abortion was not unlawful prior to quickening.
But again, Chief Justice Rush is concerned that the ACLU's argument is too broad and would go too far with the blanket right. The arguments from both sides lasted about an hour. Now the state Supreme Court will discuss and announce its ruling sometime before the end of its term, which could be as late as July. Until then, abortions remain legal during a temporary hold of the ban.